still believe that for reasons that I've expressed earlier in the day. I think we continue to talk about the issue amongst ourselves, and I couldn't really say what the nature of those conversations are. That wouldn't be fair to my colleagues, but I think it remains a non-resolved question.
Okay. Well, as a co-sponsor of what we call the CERT Act here, I hope you act before Congress does. I'd like to see the Supreme Court act on its own, but I do think there needs to be an enforceable framework, and I believe at some point there'll be the votes to do that if the Supreme Court doesn't do it itself. On a related sort of question of public confidence, I want to ask you about prediction markets, because prediction markets have faced very little federal oversight. They're largely self-regulating. We've already seen insider trading by government officials in other branches and in the military. Supreme Court justices and their staff have access to similar information. They're not immune from this trend. Here are some of the event contracts that are currently being offered on Kashi. Who will be the next Supreme Court justice? Will Trump be held liable for January 6th in any court? Will the independence of the judiciary be weakened during Trump's term? Now, clearly, members of the Senate and Senate staff could have information that could be helpful to them in playing the prediction markets. The Senate actually has now adopted, as a matter of Senate rules, a prohibition on doing that. So my question to you is, will the court do the same, both for justices and for the staff of the Supreme Court?
That's already covered.
My understanding is it's already covered.
It's already covered because there's a prohibition on using information that you know within the court to make financial gain. And so,
And not just for justices, but for all employees of the court.
Okay, so it's your view that the current language of the rules already prohibits every member of the court staff and obviously the members of the court itself from engaging in prediction markets.
I mean, I think this is an incredibly important area. So if your charge to us is go back and look for any loopholes, we'll willingly take on.
Yeah, I would suggest you
That-
do
that-
that.
we don't want loopholes, Senator Van Hollen.
This is super important.
Yeah.
I appreciate that. Well, there's legislation that's been, I think, just introduced in the House, so I think there may be a feeling that the current language may not be airtight. So if you could go back and look at that, I'd appreciate it. In terms of the shadow docket, and I followed some of your testimony in the House side, I saw Justice Kagan, you thought some improvements have been made. I think it remains a fact that during the last session of the court, more decisions were made on the so-called shadow docket than through the normal process. And I do think there are big issues here. And I'm wondering, and I'm not obviously asking about any particular case, but I am wondering about the precedential weight of a decision on the rocket docket. Now, just in the last couple of days, we've seen 2 people killed by ICE agents, one in Texas, one in Maine, in shootings. These are people who they were trying to apprehend for being here illegally. I see that ICE just halted most traffic stop arrests in the wake of these fatal shootings. That's today's news. I'm glad to hear that. But I do recall that one of the cases that was decided on the so-called shadow docket has become known as the case with the, quote, Kavanaugh stops, whether fair or not fair. That's what it's known as. And so I guess my question to you is, when the Supreme Court makes a decision in the normal course, it is binding precedent. What is the nature of the precedent or the weight that lower courts should give to a shadow docket decision?
So I think this is a complicated question, and I think you've put your finger on something real here, that there are some conflicting statements in our own precedent as to exactly what the precedential weight is. At most, it is, usually when we decide cases on the shadow docket, we're talking about the likely prospects of success, not that something will succeed, but that a claim is likely to succeed. So how one takes a ruling like that and converts it into binding precedent is, I think, a complicated question. And I think that the court itself has been of a little bit mixed mind on that question. And so I think it's a completely fair inquiry, and one that we need to keep thinking about and keep on top of.
If I could just follow up. So in a normal case, you make a decision, you, the Supreme Court, as to whether or not to grant cert or not. And when you deny cert, you don't issue an opinion. There's implication, I thought, from some of your testimony earlier that you're somehow required to take up a case on the shadow docket because they're more of an emergency nature, but there's no requirement that you take it up, is there?
Oh, it's not that we're required to grant relief, but they are motions filed, and so every motion has to be either granted or denied. So we don't have discretion to just take a pass and say we're not going to act on it.
But in some sense, when you deny cert, you're making a decision on the merits. And so I guess what I just want to leave you with is that when you grant these shadow docket motions, aren't you maybe creating an incentive for more people to file those motions? Because, as I said, you've now got a situation where you're actually rendering more decisions through that shadow docket process than through the normal process. It's almost as if you're saying that there's automatic cert in the sense that you have to make a decision. I would argue that denying cert is a decision too, because someone's looking for relief on the merits. The Supreme Court's denying cert. So when you're taking up these shadow docket cases, you're also making a decision to both take it up and at the same time either deny it or grant relief.
This is
Anyway,
part of
so
what you say that I agree with and
Yeah.
part that I don't. I mean, I think, every cert petition will deny it or will grant it. So we make a decision either way. Every application for emergency relief, we either deny it or we grant it. We make a decision either way. And we have to do that. You can't just sort of put it in a
Right.
box and say, we're just going to ignore that. I think, and I'm not sure where the number comes from, that we make more decisions on the shadow docket than we do ordinarily, because I think some of those are probably just ones, they came here, we looked at them, we said we have no interest in doing this on the emergency docket, goodbye. And if that's being counted as part of what you're talking about, well, we're just denying it.
Yeah.
But I do think, I think the part of your question that I think is a fair criticism is to ask why it is that we're facing so many more of these petitions. I think partly it's the nature of governmental action and how governmental action has changed and what kind of challenges governmental action provokes. But I think partly it's that we've granted a number of these, and so people know that it's available, relief on the emergency docket. And when people know that relief is available, there are a lot of smart lawyers out there in the world who are going to say, why don't we take our shot at that? Yeah. And so the greater percentage of these that we grant, the more likely it is that people would just think of this as part of the normal process of litigating. Hey, let's just file an emergency motion. And that's very different from what it was when I joined the court 15 years ago.
Yeah, just in closing, Justice Kagan, if you could look at that, I'd like to keep in touch on that. That is my concern, and that is also part of my question about what's the precedential value, right? If you have an incentive for more people to file these cases, and at least until final decision is rendered, maybe it's years down the line, people are going to look at this shadow docket decision as something that has influence and weight. Whether they should or not, we'll have to figure out. But I do worry because it creates this zone of uncertainty, and I also think it undermines confidence in the system. Thank you.
Thank you, Senator Van Hollen, and I want to thank the two justices today for being here. We appreciate your time and your attention. I'll remind all of our members that we have 1 week to submit any questions for the record, and I would ask the justices, if you might, to respond as quickly as possible to those questions as they come. With that, this subcommittee meeting is adjourned.